So thank you all so much for having me here today. What I've got to share with you is a presentation that goes over some of the basic rules for family law here in New Brunswick. So we'll be covering a lot of the basics about marriage, divorce, parenting children, and what the law says about a lot of those things. It's very possible I won't get through the entire presentation today. There is a lot to cover, and I'm trying to speak slowly so that the interpreters have time to interpret and so that I'm clearly understood. So if I don't finish the presentation in the time that we have here today, the slides are available. I've shared them already with the folks at the Multicultural Association. And you can also feel free to get in touch with us, ask for our contact information, and we take questions via phone and email as well if you have any questions for us after the presentation. So first, I'd like to just respectfully say that PLEIS NB acknowledges that we are located on the unceded territory of the Wolastoqiyik, Mi'kmaq, and Pescatomakati peoples. This territory is covered by the Peace and Friendship Treaties of 1725, which did not include the surrender of land and resources, but instead recognized Wolastoqiyik, Mi'kmaq, Pescatomakati title and established the rules for what was to be an ongoing relationship between two nations. So I'm here today from the Public Legal Education and Information Service of New Brunswick, or PLEIS NB for short. We are a charity that provides information about the law to people in New Brunswick. So we do try to provide as much information as we can to people who contact us, whether the question is about criminal law, wills, health law and patients' rights, really as many areas of laws as we can. And where we don't have information, we will try to refer people to the best source of that information, be it another organization or a branch of government. And thank you so much to the Multicultural Association of Fredericton for having me here today. The purpose of this presentation is to help folks who are new to New Brunswick to understand how to deal with issues like family breakup or family law and want to understand their rights and responsibilities under the laws here in Canada and in New Brunswick specifically. Separation and divorce, for example, can be really stressful for anyone, and many people are unsure about what steps they have to take, or if they do have to take any steps in order to end a relationship. And barriers such as poverty, unemployment, illiteracy, etc., can stop anyone in New Brunswick from finding out about their rights and knowing their options. So this list here just outlines a few of the barriers that we find when people contact us. They say that they've encountered as a newcomer to New Brunswick. It's possible that people who are married outside of Canada may not understand that they can actually go to the courts here in Canada to resolve issues or to end a marriage. It may be possible that people don't know that getting a divorce or ending a relationship doesn't necessarily have to affect their status, their immigration status, and so on and so forth. So we do find that we hear some common issues when people contact us with questions when they are from another country of origin. So I'm going to start off by getting into some discussions about common law partnerships and ending common law partnerships. So I'm not sure how many people here are familiar with the term common law relationship. Oh, yes, I can absolutely pause between slides. Thank you to the interpreters. So I'm going to go to the next slide for the definition of common law partnership. It means two people who live together but who are not married. That's basically what a common law relationship is. Unlike a marriage, a marriage requires legal measures to end it, but a common law relationship does not. Two people just need to stop living together to no longer be a common law couple. For common law partners, they do have certain rights and responsibilities to one another. Common law partners do not have the same rights and responsibilities as legally married couples do. So the rights that a person might have as a common law partner depends on how much time they have lived together. And there are a bunch of different laws, many different federal and provincial laws that determine what you have the right to do or get as a common law partner and what you are expected to provide to your partner as a common law partner. So some examples are common law couples can ask for a share of their partner's pension if they've lived together for at least 2 years provincially. To apply for a Canada pension split, they must have lived together for 12 months. We have a booklet available on our website called Living Common Law Rights and Responsibilities, and it discusses many of these options and these rules. If you're looking for more information, you can find that on our website. So here is an overview of some of the rights and obligations that common law couples should know about. So two people who are living together but either haven't gotten married yet or are considering getting married. So a common law couple who has children together have the exact same obligation to support their children as legally married couples do when they separate. So the rules for child support are exactly the same for everyone, regardless of whether or not they're married. The rules for spousal support. So if you separate and you need financial support from your ex-partner, those rules are different if you're not legally married. Common law couples need to show, for example, that they were together for a certain amount of time before they can apply for spousal support, whereas married couples can always apply for spousal support if they were legally married. The next question is whether or not you are financially dependent on your partner. So not everybody who asks for spousal support will get it, but married people can always ask to get spousal support, whereas common law couples need to follow a couple of extra steps to show that the relationship lasted a certain amount of time. So unlike legally married couples, common law partners are not entitled to a split of each other's property when they separate. So here, when two married people separate, the assumption is generally that you split everything 50-50. The house, what's inside it, anything that you used together as a family, even including vehicles. When a married couple divorces, there's always an assumption that you start at 50-50 and that's what's fair. With common law couples, when you separate, what's yours is yours and what's mine is mine, and we keep what belongs to us. And it doesn't really matter if it's a 50-50 split or an even sharing, because common law couples aren't assumed to have any right to their ex-partner's property. So I'm going to speak a bit about separating from a spouse. So this is talking about when two married people decide not to live with each other anymore. You don't have to get divorced right away to separate. So we're going to go over some of those rules and what that looks like. So in order to separate from a married spouse, there's no rule that you have to take any legal steps or file any paperwork. Really, the date of separation is the date you choose not to live together anymore as a couple. So for most people, that means the date that one of you moves out of the home and gets your own place. But that might also include somebody, sleeping on the couch most of the time, and you're not sharing meals together, or you're not sharing the living space, even though maybe for financial reasons you still have to live under the same roof. It's really that you're no longer living together as a couple. And two people can live apart as long as they want to. but they'll never be legally divorced until somebody files paperwork with the court to ask for a divorce. So two people can be separated for years and years and be considered, legally separated, but you're still legally married, which does have some consequences when it comes to things like property or what happens if one of you dies, for example. And it also means that you can't legally get remarried until you've had that legal divorce. There's no rule that says that separated partners can't enter a new common law relationship before they get divorced, but you can't marry that new common law partner until you get that formal divorce because it's a legal process. Finally, if two people are separated for a very long time, they might want to consider something like making or updating a will, because when a person dies here in New Brunswick, their legally married spouse is always assumed to inherit a significant amount of their property. So if you haven't gotten a divorce yet, but you're separated from your spouse and you don't want them, you don't think that they should have the right to a significant amount of your property, you might want to talk to a lawyer about getting a will made before, if you're still not ready or don't want to get a divorce. I'm going to talk a little bit about domestic contracts. So you don't have to do anything at all to be considered legally separated, but many couples create what's called a domestic contract. So sometimes this is called a separation agreement. For couples who are moving in together, it's often called like a prenuptial agreement or a cohabitation agreement is something that some people might call it. But it's any contract that two people sit down and write together and sign that decides how they're going to handle their either time living together or their separation. So for separating couples, a contract like a separation agreement might include an agreement on how you're going to handle the decision-making responsibility for your children going forward. Where are they going to live? Are both of you going to share in decisions like medical care for the children, or is one of you going to be kind of primarily responsible for that? It might include an agreement about child support or spousal support. You can decide how to share your property. And if you're agreeing to it, it doesn't have to be 50-50. You can really agree to whatever the two of you think is fair, as well as the division of anything else, like perhaps your pensions. So domestic contracts are legally binding agreements as long as everybody understands what they're signing and that they're not being pressured into it. To be valid, it does have to be in writing and signed by both of you, as well as by two witnesses who are at least 19 years old. And again, we do have more information about domestic contracts on our website, so you can find that or you can call us to ask for a copy of that information. But the main thing to consider here is that you don't have to apply to the court to settle things like parenting and property if the two of you agree and really have decided between yourselves what you think is fair. The courts are there for if the two of you aren't on the same page and you can't really agree on what's fair or what you think is best when it comes to handling your separation. So I'm going to discuss divorce next. A divorce legally ends a marriage and it frees spouses from their legal obligations to one another. It's important to know that under the Divorce Act, a spouse might be required to continue to financially support their ex-spouse. Like I mentioned before, this is called spousal support. So divorce can mean it basically ends the marriage, but it can mean that there are still ongoing obligations. For example, if I had a spouse who was financially dependent on me, if I worked and they did not, after we end the marriage, they might be able to ask the court that I continue to support them at least until they find a new job or they establish a career. And that's basically because the courts in Canada recognize that if I have a spouse at home who is maybe taking care of our children or taking care of our home, that I benefited from that, and that's an equal contribution to our marriage. And so if we separate and they don't have a career to fall back on, they do need some kind of support from me until they can support themselves. Divorce doesn't change any of the rights and obligations that parents have to their children after a marriage. So parents, if you don't live with your children, you are always expected to pay child support according to your income. You always have the same rights to make decisions about your children until you've either made an agreement that says differently or a court says differently. So the rules for divorce in Canada are in a federal law called the Divorce Act. And it basically explains what you have to do to legally end a marriage. To legally end a marriage, you must show that there has been a breakdown of the marriage. And you can do that in one of three ways. So either you have been separated for at least 1 year, or there has been adultery or cruelty during the marriage. I would say that the vast majority of people who file for divorce file on the basis of 1 year's separation. Some people think that it might be faster or easier to file based on adultery or cruelty if that's what's happened to them, because you don't have to wait a year to get that divorce. Often the process takes that long either way. And if you're saying that there's been adultery or cruelty, you also have to prove that to the court, which can be difficult and sometimes stressful. But those are the three grounds, and anybody who's filing for divorce can file for divorce on one of those three grounds, but they're the only reasons that people can use to legally end a marriage. You can file for divorce in New Brunswick if either you or your spouse has lived here for at least 1 year. And it doesn't matter where you were married. You can have been married in another province or in another country. As long as one of you has been living here for at least a year, you can file here. Now, you will need a copy of your original marriage certificate, which means that if you were married, for example, in British Columbia or in Europe, you will need to either make sure you have a copy of that marriage certificate or contact that province or country to get a new copy of the marriage certificate. So a few things that you should know about divorce in Canada. Even if your spouse does not want to get divorced, you can ask the court and a judge for a divorce anyway. There's no process in Canada or in New Brunswick that says that you both need to sign papers to finalize a divorce. It only takes one of you filing with the court to ask that the divorce happen. Now, people can contest a divorce and disagree with what you filed with, but what they can disagree with is, I don't think I should have to pay spousal support, or I don't agree with what my spouse has asked for in terms of the parenting arrangement. I want the children to live with me instead. You cannot contest a divorce simply because you don't want to be divorced. You also can't get a divorce behind your spouse's back. So there's no way to file for divorce in Canada without having to let your spouse know. So after you file the paperwork with the court, the next legal step is sending or giving a copy of that paperwork to your spouse. And you have 6 months to do that. And if you don't do it within those 6 months and have proof that you did it, the process stops there, and you either, it can't continue, or you need to withdraw your application and start all over again. So there's no way for you or your spouse to get a divorce without talking to each other about it at some point. A religious ceremony or an annulment does not end a marriage or change a person's legal status. So this is a common misconception among all kinds of people, that if they were married, for example, in the Catholic Church, there is a process within the church to have that marriage recognized as ended for a number of reasons that I'm not familiar with, but that religious ceremony is very important to people from a religious perspective, but it doesn't change anything about the person's legal status. So to end the legal marriage, you always still need to file for divorce with the courts. And the difference again that makes is in terms of somebody's entitlement to your property if you die, as well as your ability to legally get remarried. And finally, no matter how long you and your spouse live apart, there's no point at which you will automatically be considered divorced. So this is another very common misconception, that people who live apart for example, 2 years or 10 years, the divorce becomes automatic, but that's not the case. You always do need to file that paperwork with the court if you want to be considered legally divorced. So, a few things about sponsorship and divorce. When you sponsor someone to come to Canada, you sign a sponsorship undertaking, and that undertaking is a very serious promise. If you change your mind about sponsoring a spouse or your common law partner because, for example, you've broken up and you're no longer a couple, you must contact the Immigration and Refugee Council of Canada by using a web form to inform them of that decision. And a sponsor can only stop their sponsorship status before the visa office has issued a permanent resident visa. Once that permanent resident visa has been issued, the promise that you made to support your spouse or partner is in effect for 3 years after that person becomes a permanent resident. So that means that even if you and your partner separate or divorce before the end of that 3-year period, you, if you're the person sponsoring, must still support your spouse or partner financially until that 3-year period is over, even if you're no longer together. This information I accessed through the Government of Canada guide on sponsorships for spouses and common law partners. So you can find that online as well. And if you're looking for more information, again, you can contact us and we can tell you how to find that. So a divorce or a separation does not end anyone's obligation to sponsor their spouse if they've signed that undertaking. And there are a lot of people who are worried about that. If they want to end a relationship because they're not happy anymore, or it might be abusive or violent, they might be worried that it will affect their immigration status. And in some circumstances, it can. But that sponsorship undertaking is very serious and doesn't end just because the relationship has ended. So, a little bit about marital property and debts when two people separate. This section talks about the New Brunswick Marital Property Act, which decides how property gets divided when a married couple separates. Um, this information is specific to married couples because, as I mentioned in the section on common law couples do not have a legal right to property when they separate. You take what belonged to you, but there's no law that says that you can ask for your ex's property. So what is marital property? Marital property, it means family assets, so belongings that a married couple acquired either before or during their marriage and were used for the family. So most commonly, that means the home that you lived in or cottages that you might have used as a family. It means everything inside the home, such as furniture, appliances, household goods. It does include bank accounts and investments that you had together as a couple, cars and recreational vehicles, and it also includes pensions. Spouses don't have to share marital property that is not considered marital property. So there are exceptions to this where there is some property you can own that falls outside of this definition. Most commonly, an example might be an inheritance isn't necessarily considered marital property. unless it's the home you lived in that case, it's a little more complicated than that. But generally speaking, an inheritance is not marital property. Neither is property owned by a business you own or run. Again, some exceptions to that, depending on whether it was a family-run business or not, but the general rule is that business property is not marital property. Once a divorce is final, you only have 60 days to decide how to divide that marital property, so it's usually best to do it sooner than later. So the law recognizes that both spouses are equally important when it comes to a marriage, running a household, and managing finances. Uh, when it comes to raising children, for example, there's an assumption at law that both spouses play an equal role and in managing their house. So because of that, the law assumes that married couples should split their belongings 50-50 to recognize that equal partnership if they end the marriage. Um, that doesn't mean that you will always have to split your property 50-50. So you can either do it differently because the two of you have agreed that it's more fair to do it that way. And you can agree to whatever you like, again, in a domestic contract. Or if you don't agree, but one of you thinks it's really unfair to do it 50-50, you can ask the court to do it differently than 50-50. Some common reasons for that would include if one person is walking away with a lot more debt, they might also want to ask the court for more of the property. If one person is going to remain in the home and keep the home, then they might get a little less of everything else. So there is a give and take here, but we always start with 50-50. That's fair. And then let's see whether maybe we can discuss otherwise. So you can ask the court to divide your marital property after you separate. You can do that at any time after separation, even if you're not getting a divorce yet. You can also do it when you file for divorce or after the divorce, but then you only have 60 days. So it's a very narrow window, and it's usually best to take care of it early. Another note is that if you have marital property that's located in another country, even in another province, the courts in New Brunswick cannot make an order about it. So, for example, if you still own a home in another country, you may need to go through the legal system in that country to decide how it has to be divided and follow their rules, because the courts here have no authority over how things get handled and how property is managed in another place. So next, I'm going to get into a little bit more detail about spousal support, which we discussed earlier is it's money paid by one spouse to the other after the relationship has ended. It's sometimes called alimony or maintenance by folks who might be more familiar with those terms. They're not used in our legal system, but they're older terms that some people are more familiar with. Unlike child support, spouses are not automatically entitled to spousal support. So you have to prove that your partner has a duty to provide for you. Otherwise, the law assumes that you have a responsibility to take care of yourself. So this means that any ex-spouse or partner who can work and earn an income is expected to do so to the best of their ability. And once they've done so, if there's still a gap, like a significant gap between the two people's incomes, then they might still be entitled to spousal support. If one spouse is disabled and can't work, for example, that might be a reason to order spousal support. If one person never went to school or pursued a career because they were taking care of the home, then they're going to need some time to find, a way to support themselves. So they might be entitled to spousal support. Or simply if there's a huge difference between your two incomes based on the two career paths that the two of you have followed, there might also be spousal support. So again, if you suffered a career delay during your marriage, stayed home or only worked part-time to raise the children, or if you moved around a lot to follow your spouse's career so you could never hold down a job, that might be one reason. Um, if for any reason you can't support yourself either now or ever, that's another reason that you might want to ask for some advice about getting spousal support. Um, it's generally a good idea to get advice from a lawyer if you have, specific questions about your entitlement to spousal support, because it's not an automatic thing that you can always get. It's usually a good idea to get advice from someone about how to approach that kind of a request if you have to go to court to ask for it. And it might be worth contacting somewhere like legal aid about that, because I do believe they will help with applications for spousal support if people meet their financial criteria. For common law partners, they must have lived together for at least 3 years, during which one of you was financially dependent on the other, or you must to have lived together fairly continuously and had a child together, and one of you was financially dependent on the other. So basically, if you were financially dependent on a common law spouse, you can ask for spousal support if you live with them for 3 years, or if you live together and you had a child. And it doesn't really matter how long you lived together, as long as you had a child while you were together. So, a bit about decision-making responsibility and parenting time. This used to be called custody and access in Canada, but very recently in 2020, there were some changes to the law that changed this terminology. So I'm going to get into what this means and what we mean when we say these two things in a legal sense. Decision-making responsibility refers mainly to making major decisions about a child and their well-being. Um, Parenting time actually is what refers to actually being with the child and having them in your care, whether that's all the time, whether it's on a specific schedule, every second week, or just on the weekends. That's your parenting time when you have the children in your care. And the decision-making responsibility is that legal responsibility that you have and authority that you have to communicate with schools, to make decisions about medical care, religious upbringing, all kinds of things that go into a parent's legal authority to make decisions about the child and to interact with formal institutions about their child. It's worth noting, I'll get into this in a bit in the next slide, but the law recognizes that both parents have an equal right to both of these things. Um, some common situations that you see when couples separate would include maybe sole decision-making responsibility, which means that the parents have agreed to, or the courts have ordered that only one parent has final say about major decisions, about school, medical care, those kinds of things. You also might see joint decision-making responsibility, which means that both parents have an equal say in those things, and they both must give their permission for all of those things. You see that most often in couples who are still able to communicate well and look out for their children's best interests after a divorce. And you see it less often in situations where the parents might be really high conflict and can't, come to an agreement for their children's best interest. You also see for parenting time situations where maybe one parent has the majority of parenting time. So usually that's defined as 60% of the time or more. And then the other parent having a scheduled time to see the children. So that could be, every second weekend. It could be only on the weekends. It can be really whatever schedule works for the family and is best for the children. You also see shared parenting time, which means both parents have an equal amount of time with the children. So most often you would see this as opposite weeks, like the children spend 1 week with one parent and then another week with another, or 2 weeks and 2 weeks. But it can really be any arrangement that is roughly 50-50 or 60-40 amount of the time. And then finally, sometimes you see split parenting time, and that refers to parenting arrangements where each parent has, the most of the time, at least one of the children living with them. So basically it means siblings aren't living together because each parent has at least one of their children living with them most of the time. Oops, sorry. Okay. So when it comes to decision-making responsibility and who gets it, parents can make a domestic contract, like I said, if they both agree about what's best for their kids and what they think the parenting should look like. Um, or they can ask for a court order. If there's no court order or agreement, even if parents weren't married, the law assumes that you both have an equal right to make decisions about the parenting of your child. So you have an equal right to know about their medical care, an equal say in registering them for school, an equal right to have them be with you and to spend time with them. And if you can't agree and you can't make that kind of arrangement because the two of you aren't on the same page about what that should look like, you can apply to the court. And the court will look at what they call is in the best interests of the child. And that's a defined term. There's a test laid out in the Family Law Act. So a judge has to look at the following things when deciding what's in the child's best interest. We look at the child's needs mentally, emotionally, and physically. We look at what effect a disruption in their routine would have on a child. We look at the love, affection, and ties between the child and each of their parents. We look at the plans that each parent have to care for that child and what their arrangements already look like. We look at the stability of each of the homes, the child's cultural or religious background and the need to maintain those ties. And we look at the views and preferences of the child. There's a number of other things that the court might look at under this test. And again, we have some information about that on our website in a chart that's called the terms under the Divorce Act. And we can help you find that if you get in touch with us. Another thing that the court might consider is the willingness of each parent to make sure that the child spends time with the other parent. So if one parent really won't cooperate or communicate with the other parent, that might be one reason the court doesn't give them the majority of decision-making responsibility. Courts really do want to see parents try to cooperate together to parent their children whenever possible. There's always going to be exceptions in cases where there's been family abuse or violence, but in the majority of cases, courts really do want to see people trying to come together to communicate in the best interests of their children. Sorry. So what is parenting time? So like I said, that refers to the periods of time that the children are in the parent's care. The purpose is to make sure that children have a meaningful relationship with both of their parents without a major change to their status quo, which means their routine that they're already familiar with. Parents can always agree on a parenting time schedule as long as they are both on the same page and agree what's best for their child. And when making that kind of schedule, parents, or if you've applied to the court, a judge, might consider the time that each parent has already spent caring for the children before separation, how old the children are, and the work schedules of each parent. There's really no default schedule at law. So if you go to court, there's really no schedule that most people can expect a court to order. They're always going to look at that individual family and those specific children to try and figure out, what's best for everybody here. So a note on traveling with children. When you're traveling with children, it's usually a good idea to have documents with you. So a copy, well, your child's passport, your child's birth certificate, which should include the names of both parents. So that means the long form birth certificate. It's usually a good idea to have a letter of consent saying that you can travel with the child, written by the other parent or anybody who has decision-making responsibility. Um, a copy of a court order that gave you decision-making responsibility or the right to travel with the child, especially if you can't get that letter of consent from the other parent, or any other documents that might be required by the country you're visiting. And this is basically because when two parents separate and only one of you is traveling with the child, authorities might have some questions about whether or not you have permission to have the child with you or not. There are always going to be concerns about parental abduction, for example, or if you need medical care, even traveling from province to province, if there's a medical emergency. And you can't show that you have decision-making responsibility alone, medical providers might need you to get permission from the other parent to have medical care given to your child, or some kind of paperwork to show that you have that permission while you're traveling. So it's usually a good idea to gather these documents before making travel plans outside of the province with a child if you separated from the child's other parent. So a note on child abduction: if you're worried that the other parent will take the child and take them out of the country without your permission, it's always a good idea to proactively let a lawyer know and considering letting the police or the RCMP know so that they can make a note to watch for the passport, for example. If your child is a Canadian citizen, you can tell Passport Canada that you don't consent to your child being issued a passport, and that can add your child's name to the passport control list. So again, it's just one extra step where there's somebody who's going to be looking out for that at the airport or at a border. You can also ask, if you're going to court, that a judge order that the child's passport be retained by the court or kept in a specific place. And it's always a good idea to record and keep all information that you have about your child and your decision-making responsibility and parenting time arrangements. So if that's a court order or a separation agreement, make sure that you have copies of those so that if anything goes wrong, you have that paperwork on hand. The final note is just making sure that your child knows how to contact you and how to use, a payphone or a cell phone if anything goes wrong. So on to child support. We have a pamphlet on child support as well. It's on our website and we have a print version as well. So again, there will be some information at the end of these slides about where to contact us, but you can also get that information from the folks at the Multicultural Association. Child support is the money that's paid by one parent to the other parent to support their children. So that usually means that the children are living with one parent at least 60% of the time, and the other parent is paying them to care for those children. It's meant to cover the costs of raising that child, like feeding them, clothing them, housing them, and providing for their everyday needs. Legally speaking, it's considered the right of the child to have that financial assistance and not the right of the parent who's receiving the money. The parent is really receiving that money to benefit the children. It's not that parent's right to get money, it's the children's right to have support from both of their parents, which is why it's non-optional and parents don't have to prove an entitlement to child support. If you have children and you don't live with them at least 40 to 60% of the time, then you're always assumed to have to pay child support according to your income. And what I mean by according to your income is that there are federal child support guidelines. And this is a series of tables that set out the basic amount of child support that someone has to pay to the other parent if they're caring for the children. This is legislation and it's mandatory for everyone. It's based on a person's annual gross income. So if you're the paying parent, it's based on your annual gross income. And there's a calculator available online through Justice Canada that can help you figure out how much you might have to pay if you were paying child support. So it asks you for the tables are based on your annual gross income, the province you live in, and how many children you have or are paying for. And based on that information, everybody with those same three answers will have the same amount. It's just a table. So it's based on your income and the number of children. And there's a table for New Brunswick. And everybody who makes $50,000 a year and has 3 children gets the exact same amount that they're expected to pay. These guidelines govern how the payments need to be made and how courts decide how they get made. And they apply to all separated parents, whether they were married or not. Child support can be affected by the parenting time arrangement. So if you have roughly 50-50 amount of time with the children, or even 60-40, you're not expected to pay the table amount of child support. So the number that calculator would give you, it's a little different in situations where you have shared parenting time. So if that's your situation, there's information online through the federal child support guidelines to get more information about how that would be done. Or again, you can contact us if you have questions. So special expenses, this is money paid over and above that table amount of child support. So these are expenses that are not typical everyday costs when it comes to raising a child. And common examples are special expenses for education, and that might include things like private tutoring if the child needs it, orthodontics, so if a child needs braces, childcare, daycare, extraordinary medical expenses, so maybe glasses, for example, or high medical costs for prescriptions a child might need, and so on and so forth. So parents can agree among themselves how to share those special expenses and how they will contribute. Maybe one of you has insurance, and so you might want to make a decision based on that. But usually what happens, and if a court is ordering, making an order that involves special expenses, they're going to be shared in proportion to your incomes. And by that, it basically means if one spouse makes $30,000 a year and one of you makes $70,000 a year, together that makes 100,000. So that's 100% of the cost. So the spouse who makes $30,000 maybe only pays 30% of those expenses, and the spouse who makes $70,000 pays 70% of those expenses. It's kind of shared equally according to how much you make, not equally based on 50-50. So if you can't agree on what you would think would be fair, you don't have to do it according to your income if you think that something else would be fair. But if you can't agree, the court will decide what's fair. And often they're looking at that proportionate income amount. So when child support ends, so child support continues until a child reaches the age of majority. In New Brunswick, that's 19 years old. But it might continue after a child is 19 in certain circumstances. So one example would be if the child is enrolled full-time in post-secondary education. So if a child is going to college or university, a parent might be expected to continue to pay child support. If a child is disabled and unable to care for themselves when they turn 19, that's another reason that child support might have to continue. It's always decided case by case. So if this is a situation that you're in, you might want to ask a lawyer about it. To apply for child support, again, the two parents, when they separate, can agree to start making child support payments based on what they think is fair. But if that doesn't happen or they can't agree on the amount, then one spouse can apply to the court for a child support order. That is done by way of an application in family court. It's a somewhat complex process, but it doesn't have to be. And there are ways to get help. So the process is different in every province. It's specific, to New Brunswick, and New Brunswick actually has two different rules depending on whether you live in Moncton and St. John or anywhere else. So if you need information about how to apply based on where you live, you can contact legal aid. And if you qualify for legal aid based on your income, they can provide you with a lawyer who helps you through the application process. Another option would be to contact us and go to our websites. We have one called familylawNB.ca. And on there, we do have a guide on how to apply for child support. So it's a PDF that's about 80 pages long that walks you through the process and shows you some of those example forms. And likewise, you can call us if you need it explained to you, or if you just want help figuring out where to start. You can always contact us for some help. We can't give legal advice on what people should say on their forms or say to the court, but we can give information about what you need to do. So what steps to follow, what forms to fill out, where to take them, those kinds of things. And if you have a child support order, you can enforce it, which basically means if somebody isn't paying, there are steps you can take to make sure that they're told they have to pay. The Office of Support Enforcement, or the OSE, is a government body. They're an organization within the government of New Brunswick that most child support orders are automatically filed with them. Once the court makes that order, it automatically gets sent to them. Parents don't have to have their orders enforced through the OSE if they don't want to, but if you don't want them to help enforce it, you have to contact them and tell them so. Otherwise, every month they're going to be making sure that those payments get made through them. So a parent who has a child support order that's filed with the Office of Support Enforcement is usually expected to pay the office, who then forwards the payment to the receiving parent. And that basically means that every month they're seeing whether the payments get made and whether the payments are being made in full. If somebody misses a payment, the Office of Support Enforcement will follow up and let them know. And after 3 months go by, if payments are being missed, they can start taking other steps. And over time, those steps can include filing in the court for a contempt order. They can have somebody's driver's license suspended, other pieces of documentation suspended. So it can be quite serious if you have a child support order and aren't paying it, especially if it's filed with the Office of Support Enforcement. So we have a little bit of information here about family law and immigration status. I notice I have about 5 minutes left. Let me just double check how many slides I have left, because I might rather take these 5 minutes to cover some questions, if that's okay, and provide the slides to you folks so that you can share them around, because I have about 10 more slides to go. But I'm thinking I might put up our contact information and ask for a few questions instead. Is that all right?
Yeah, that works.
Sure. Okay, perfect. I will just skip to the page about our contact information here. So this is a number of community resources, but you'll notice the Family Law NB is our family law website. We have a toll-free line that you can call to get information about family law with our family law information officer, who's there every day answering the phone. You can contact legal aid, et cetera, et cetera. So I have a few minutes, and I know you folks do. If anybody would like to ask me some questions, I can do my best to answer them or tell you where you can go to get more information.
So if anyone has any questions for Amber, please type in the chat box and she'll be answering it.
I hope that means that the presentation was very clear if there are no questions.
Yeah, it was a really good presentation. Thank you so much for that.
No problem at all. And like I said, feel free to share these slides with anybody who would like them. Get in touch with us at Public Legal Education if you have any questions, even if it's not about family law. We can answer your questions about wills, about housing and renting in New Brunswick, a number of different things if you just have questions about the law and don't know where to start.
All right. So it looks like we don't have any questions.
Okay.
So far. Thank you so much, Amber, for the amazing presentation. Thank you, the interpreters and the teachers. I really appreciate it.
Thank you so much for having me. Thank you, everybody.
Bye-bye. Have a good day.
Thanks, you too.